Recalling case 25-20560, United States of America versus David Taylor.
Sarah Cohen, on behalf of the United States.
Thank you.
Just put your appearance again on the record, please.
Oh, Scott Rosenblum. I'm sorry. I was just getting notes for what you're going to say.
Oh, okay. All right. Mr. Taylor, I'm going to say some things that the folks in this courtroom have probably heard a couple more times today, but it is part of my decision-making process. And the first thing is you are entitled to the presumption of innocence. There is nothing that has taken place in this hearing today, anything that was in the government's proffer, its memorandum, or anything that I might set forth in any finding that's intended or should affect that presumption of your innocence. And this is a detention hearing, and it's governed by the Bail Reform Act. And that act says that detention is considered an exceptional step. Bond is presumed unless it is determined that there are no conditions or combination of conditions that will reasonably assure your appearance or reasonably assure the safety of the community. And the act requires that I impose the least restrictive measures to provide those reasonable assurances. Now, in your case, with the charges that you are facing, it is a presumption case. And that means that these charges are so serious by their very nature that Congress has decided that it is presumed you don't get bond. But as your lawyer said, that presumption can be overcome. And I understand the government has a belief that they haven't overcome the presumption, but you just need some evidence to overcome it. You don't have a criminal history, and you have ties to varying communities. So I'm going to assume that you have overcome the presumption of detention. But then I have to look to the 3142G factors. They were all talked about here today in some way, shape, or another, and they're in the government's brief, and they're talked about in the brief that was filed by your lawyer. The first is the nature and circumstances of the offense. It's laid out in the indictment. It's very serious. These allegations are horrific. I understand that this is ostensibly a church, but from where the court sees it, it has serious questions. If churches that I know don't operate in this manner, and this is a presumption case, and so this factor, the nature and circumstances of the offense, and I understand you have what you have telling me a formidable defense to what is laid out in the indictment and the nature and circumstances. But what I'm looking at, it's serious. It weighs in favor of detention. Then I consider the weight of the evidence. It's not the weight of the evidence of your guilt or innocence. It's the weight of the evidence as to your risk of non-appearance or danger to the community. And as to your risk of non-appearance, the government has set forth here today and in its memorandum, that you have some financial means, potentially. I don't know if it's super significant for you to go a lot of places, but what's really concerning about me is that you have ties so many different places, in so many different states, and you have supporters, I'm hearing, 200,000 people, and that gives me some concern that you are a risk of non-appearance through your ties and your supporters. And they only have to convince me by a preponderance of the evidence. And they've come really close to that. But I'm mostly concerned about the danger to the community, and they have to show clear and convincing evidence. And I look at what's set forth in the affidavit. Those aren't just, there's allegations, yes, but there's actual text messages that are set forth that enhance what's in the affidavit. And then I heard in the government's proffer today, and I understand this is an ongoing investigation and they are still uncovering things. And the things that they have told me today that they have uncovered are very concerning, very disturbing, and, indicative of your dangerousness. And I think your history and characteristics as well. You don't have a criminal history. And by your lawyer, you've been, serving in this ministry, and you have supporters here who believe in you. And, that would be a good thing in your favor, but it also cuts the other way too, because what's laid out here in this indictment and what I've read is really concerning, Mr. Taylor. You are alleged to lead this organization that is alleged to have engaged in some activity that is incredibly troubling, concerning to the court. So I think this all speaks to your dangerousness to the community, and I know your supporters completely disagree, but you don't have all just supporters. There are people who, you're going to have your witnesses at trial that say none of this happened. They're going to have their people that tell a very different story, and that's not unusual in situations like this. But from my vantage point, I'm extremely concerned. I'm also really concerned because there's no real good place right now for me to tell you where you could go, where you would be. No, you let me talk.
Okay.
You've talked. I know you proposed an address in this district that hasn't been vetted by pretrial services. I have no idea where that is. You don't have, you have some ties to this district. There was a church place here. But I'm not convinced that anything pretrial services has offered. I think one of the bond conditions of your co-defendant was to be completely separated from the church. I don't think that's possible here. I don't think there's any bond condition where you're proposing to live in North Carolina. That's still part of this whole organization. That's still part of it. And your supporters, if I understand what the government's saying in their investigation, part of that is to protect Mr. Taylor. And I don't know how the extent that protection might go. But Mr. Taylor, I think the only way I can keep the community safe and, to separate you from this organization, that's the only bond condition I could think, that would I could possibly consider. I don't know how to do it at this point. And bond requires trust. And, you say there's some discrepancies in the pretrial services report. But for me, I could see that you weren't completely forthcoming with the pretrial services officer. And I have a problem with that. That's your opportunity. And it doesn't appear that you were fully transparent. These allegations, what the government said in its proffer, I understand that the co-defendant, that individual did get bond, but I think these supporters heard, earlier in the case before this, I look at the cases individually, and your particular role, these particular allegations, what the government has said in its proffer, I do not believe, and I understand that we've got 2 pretrial services report that recommended bond with conditions, but from my vantage point, I do not believe that any of those conditions are sufficient to really assure your appearance and assure the safety of the community. And I know this ruling will come as a great disappointment to all of you who are sitting there, who are supportive of this, but that's my decision. And I'm going to enter an order that keeps you in custody pending the resolution of your case. You do have a right to appeal. I fully expect that you will. No matter what my decision was today, somebody was going to appeal. And to that end, I have been informed that Judge Berg has Tuesday, October 21st at 9 o'clock available should there be an appeal that needs to be heard.
We'll take that date.
Well, you'll have to take it up with them. But,
right.
Your lawyer did a good job on your behalf. I just happened to disagree with him on the arguments that he made. And I agree with the government on this one, that detention is warranted. I have nothing further. Thank you.
I don't want no government cheese. I don't want no government milk. And I don't care how fresh it is. Why give me cheese when I can build a cheese factory?
Lord, there's something about your name.
I am ruined forever. Face to face with Jesus ruined me forever from religion.
He tweets on Twitter. I mean, this is national news.
I'm not no liar.
Instead of faking like I had.
Are you an idiot? Did you just hear what I said? You a big idiot.
And I'm just crazy.
Fair use copyright disclaimer under Section 107 of the Copyright Act 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, education and research. Fair use is not an infringement of copyright. All my content is found on the public domain. I follow the fair use dealings and fair use guidelines with my opinions and news that I report to my subscribers about the topic of Apostle David E. Taylor and the JMMI cult.
A cult disguised as a church?